What do heirs wish parents had done before they died? Heirs usually wish parents had handled 7 things before death: put the house in the right estate plan, transfer the deed correctly, explain the plan, organize the documents, fix major repairs, give someone legal authority, and disclose debts, insurance, and tax issues. That is the core answer, and it is what prevents most of the fights, delays, and surprise costs families run into after a parent dies. I am Rhett Fruitman, co-founder of Inherited Property Match. My background includes City Private Bank, CBRE, and helping families navigate inherited property sales across the country. This is general information, not tax, legal, financial, or real estate advice. Before you sell inherited property, speak with a CPA, and when probate or trust administration is involved, an estate or probate attorney. What would heirs say first if they could coach their parents now? They would say, do the planning while you still can, because it is far cheaper and easier than cleaning it up later. Does a revocable living trust avoid probate for a house? A revocable living trust can help keep a house out of probate, but only if the home is actually transferred into the trust before death. That is the detail families miss. Signing the trust document is not enough. The deed has to be recorded in the name of the trust, and the trust should name a successor trustee who can act after death. What happens if the trust exists but the deed was never transferred? The house can still end up in probate as if no trust existed. A will can say who should receive the house, but a will by itself usually does not avoid probate. A properly funded trust or another valid probate avoidance tool available in that state is what usually keeps the house out of court. What heirs wish their parents had done was create the trust, transfer the deed, confirm the title work, and make sure the successor trustee knew where the documents were. Why should parents talk about the inherited house before death? Parents should talk about the inherited house before death because silence creates assumptions, and assumptions create sibling conflict. One child thinks they will keep the house, another thinks it will be sold. A third assumes they will do all the work because they live nearby. When nobody has a clear plan, the family has to negotiate while grieving. What should parents tell children about an inherited house? They should say whether the house should be sold, kept, rented, or offered to one child through a buyout. The best answer is simple: say who gets what, say what should happen to the house, and put the plan in the estate documents. A family conversation helps, but the legal documents are what give the plan authority. What repairs should parents handle before leaving a house to heirs? Parents should handle major deferred maintenance before death because roof, Eichwach, plumbing, and electrical problems become harder and more expensive for heirs after a death. Those problems do not get cheaper with time. They get passed to the heirs, and by then the family may be forced into a rushed sale, a repair credit, or a lower cash buyer offer. A neglected house also shrinks the buyer pool. Heirs do not need perfection. They need a house that is still sellable. What should parents do if they cannot fix everything? Fix the big issues if possible, and at least document the condition with photos, invoices, warranty information, and inspection reports. That record can help heirs understand the property and support a date of death appraisal later. What documents do heirs need after a parent dies? Heirs need one accessible file with the deed, will or trust, mortgage information, insurance policy, property tax bills, utility information, keys, access codes, and contact information for the attorney, CPA, insurance agent, and lender. When heirs cannot find those documents, everything stalls. People waste time searching drawers, boxes, and old filing cabinets when they should be securing the property and handling the estate. What else belongs in that file? Parents should leave death certificate instructions, online account access details stored securely, HOA information if there is an association, and enough property information for heirs to order a date of death appraisal if a CPA or attorney recommends it. A letter of intent can help too. It can explain practical details like keys, neighbors, alarm codes, vendors, and wishes for personal belongings. But a letter of intent is not a substitute for a will, trust, deed, or valid estate document. It helps heirs understand the plan. It does not create legal authority by itself. Who makes decisions when siblings inherit a house? When siblings inherit one house, parents should leave a written sale, buyout, or decision-making plan and give one person clear legal authority through the estate plan. That person might be a successor trustee, executor, or personal representative, depending on whether the property is in a trust, a probate estate, or another structure. Who can authorize the broker, the listing price, repairs, and the sale timeline? Those questions should be answered before death, not argued about after. If one child wants to keep the house, the plan should explain whether a buyout is allowed, how the price will be set, and how the proceeds will be split. If the house should be sold, the plan should say who can sign and who manages the process. The goal is not to control every detail from the grave. The goal is to prevent deadlock while the family is emotional, busy, and under time pressure. What should parents disclose about debts, insurance, and taxes? Parents should disclose the financial picture of the house before death because hidden loans, insurance gaps, and tax surprises can delay or damage a sale. A mortgage can still exist when the family thought the home was free and clear. A HELOC may freeze or require payoff. A reverse mortgage can create real urgency after the borrower dies. Homeowners insurance can also change when the house becomes vacant or moves into an estate or trust. What happens to a mortgage after a parent dies? Heirs need to know the lender, loan balance, payment status, policy number, insurance agent, property tax status, HOA dues, and any liens or special assessments. Before a sale, heirs should also ask a CPA about stepped-up basis and capital gains. The tax result can depend on the date of death value, sale price, improvements, selling costs, and state rules. What is the best way to protect heirs before an inheritance? The best way to protect heirs before an inheritance is to make the estate plan clear, make the title match the plan, put documents in one place, and introduce the family to the right professionals before there is a crisis. That usually means an estate attorney for the plan, a CPA for tax questions, and a real estate broker who understands probate, trust, and inherited property sales. If you inherited property and need help finding a broker who understands estate-related sales, Inherited Property Match can connect you with a vetted broker experienced with inherited property. The match is free. You can read the full article and related guides in the description for more on trusts, probate, taxes, insurance, sibling decisions, and inherited property sales.